Ethan Wentworth and Rusty Herr operate No Bull Solutions, a reproductive management company for dairy cattle, operating out of Pennsylvania. On April 10th, Rusty Herr was arrested at a county office. On April 11th at 6:45 a.m., Ethan Wentworth was arrested from his home in the presence of his family by local law enforcement. Both men were admitted to their respective county prisons, where they served a 30-day civil sentence without opportunity for bail. At the time of their arrest and imprisonment, the men, their now attorney Robert Barnes, local news outlets, and even the State Veterinary Medical Board allegedly had no idea as to why they were arrested and imprisoned without bail. As news of their arrest broke, stories began to circulate that this was an arrest without due process. Due process being a constitutional right, twice instated, first in the Fifth Amendment and then in the 14th Amendment. The Fifth Amendment citing, "No person shall be deprived of life, liberty, or property without due process of law." ACLU Pennsylvania, citing due process, guarantees the government cannot imprison someone or take away his or her children without allowing the person to challenge the government's actions. I spent about 3 days combing through state and county records to retrieve a timeline that would either confirm or deny that due process was provided for these men in this case. I'm going to provide you that timeline with none of my personal commentary interjected, but I do have some comments at the very end. I invite you, the listener, to listen very closely, and do feel free to leave your opinion in the comments below. Something that needs to be noted about this particular timeline is that what happens from 2021 forward and what happens before 2021 are two separate cases. However, I'm presenting the timeline from 2010 forward because the context is necessary to give you a full picture of exactly what led into the men's ultimate arrest. In 2010, the Pennsylvania Veterinary Medical Board imposed a fine of $3,500 on Rusty Herr at No Bull Solutions for illegal practice of veterinary medicine by unlicensed individuals. The basis of this allegation was the fact that Rusty Herr was using ultrasound technology without a license to confirm pregnancy in bovine and for suturing a displaced abomasum in cows that he did not own. According to the Veterinary Medical Board, this violates Pennsylvania's Veterinary Medical Practice Act of 1974, which in essence cites that the profession of diagnosis, prevention, treatment, or testing for the presence of disease or physical conditions is to be occupied by licensed veterinary professionals only. At this time, the Veterinary Medical Board worked in tandem with the Department of State's Bureau of Professional and Occupational Affairs to impose the fine and a cease and desist order on Rusty Herr at No Bull Solutions. Do keep in mind here that veterinary medical boards have no legal authority against private business, but what is often the case is that entities like veterinary medical boards will work in tandem with state agencies that do have a higher level of authority. It allows an otherwise powerless entity to attain the legal authority it needs to bring fines and cease and desist orders against private businesses. When now attorney Robert Barnes was asked as to why Rusty Herr did not at this time respond, he did clarify that he was not Rusty's legal counsel at the time. However, the advice of former counsel was that these orders did not apply to Rusty's business. Rusty was not using sonogram to diagnose or prevent disease. Sonogram was used to confirm pregnancy in cattle, which is neither a diagnosis nor a disease. In 2018, the Pennsylvania Veterinary Medical Board goes through the same process with Rusty Herr's business partner, Ethan Wentworth, imposing fines and issuing a cease and desist in collaboration with the Department of State, this time exclusively on the basis that Wentworth was using sonogram technology without a license to confirm pregnancy in cattle. Wentworth did not respond to the cease and desist order. In 2020, the Pennsylvania Veterinary Medical Board escalates its complaint against Ethan and Rusty, this time filing with the Professional Compliance Office at the Department of State and requesting that contempt charges be filed against the men. Quote, "Since these individuals continue to practice veterinary medicine without a license after their original order to cease and desist, we request that the state file contempt charges with the Commonwealth Court." At this point in time, records went completely dark. No further information was made available to the public as it pertains to the state's actions against Ethan and Rusty's business until breaking news stories of their arrest 4 years later in April of 2024. Ethan and Rusty sat in prison for 2 weeks. Their now attorney Robert Barnes and even members of the Veterinary Medical Board, which, if you do remember, was their primary antagonist for 7 years, were caught off guard by the nature of the arrest. It was on April 26th that the state of Pennsylvania unsealed Ethan and Rusty's civil case, revealing 2 years and 7 months worth of hidden records. Now, if you're familiar with the term sealed and unsealed as it pertains to court cases, you will know that in the United States, a majority of cases are left unsealed. They're visible to the media, to legal representation of all types, and even the general public for the entire proceeding of that case. Sealed cases are hidden from the public eye, and details pertaining to the case can only be obtained by court order. Sealing a case is very rare, a privilege typically exercised in things like juvenile cases where privacy concerns for minors are involved. And it was because the case was sealed that no details were available at the time of Ethan Wentworth and Rusty Herr's arrest in April of 2024. The case is now freshly unsealed, and I have direct access to the court docket for it, which I will actually link that court docket below so that anyone who wants to can review it themselves. But here are the missing pieces taken directly from court records. In February of 2021, Judge Michael Wojcik approves the state's subpoena request for Ethan and Rusty's business, No Bull Solutions, demanding that Ethan and Rusty hand over records relating to, quote, the performance of fetal sexing, pregnancy examination, ovum pickup, embryo transfer, and ultrasound services performed on bovine. October 20th of 2021, the subpoena was served, and a certificate of service is filed. A certificate of service being proof that the subpoena was delivered legally and successfully. Something to note here is that when it does come to legal papers like court orders or subpoenas, states are required by law to formally serve them upon either the individual being subpoenaed or a representative of the company in question. These papers have to be physically presented to a person or mailed in such a way as to confirm delivery. The reason being here is that to ignore a state-issued subpoena or a court order puts an individual in contempt of court, which in the state of Pennsylvania subjects that individual to time in prison without bail. At this point in time, once that initial subpoena was served, Ethan and Rusty had 30 days to turn in records. No response is recorded on behalf of Ethan and Rusty. December 7th, 2021, a hearing was held. No response or counteraction is recorded on behalf of Ethan and Rusty. This entire process, which would qualify as due process, was repeated once again in 2023, before Judge Michael Wojcik finally signs an arrest and incarceration warrant for both men on October 6th, 2023. 6 months later, on April 10th and 11th of 2024, Ethan and Rusty were arrested and imprisoned for 30 days without opportunity for bail. Now, having assembled this timeline straight from court records, I was left with significant questions. 2 men allegedly having no idea as to why they were imprisoned, while court records do show they were formally served court orders at least twice, with 2 opportunities to appear at a hearing. The state's actions here are undeniably suspect. Sealing a case from public eye for 2 years and 7 months, and not unsealing it until the individuals in question have been imprisoned for 2 weeks is questionable beyond a doubt. A state granting the request of a veterinary board to impose civil contempt charges on a private business, which a judge then signs off on, is once again highly questionable. But are we really looking at a situation in which we can say that due process was not served by the state? Is it really possible that neither Ethan nor Rusty ever laid eyes on the subpoenas or court orders that were issued against their business, however just or unjust those may have been? Were these men really not given the ability to go to a hearing and tell the judge pregnancy is not a disease, and using ultrasound technology to confirm pregnancy is neither diagnosis nor treatment? And as I pose these questions, I do not want it to seem as though I am advocating for the state against a small business. But here's the thing. There is a lot to complain about with respect to state or even federal overreach. But it is so important that we make those complaints and those allegations with proper facts behind us, or we run the risk of looking really ignorant. And that is not a good reflection on the food freedom community at all. I just have a few more questions and a few more contacts that I am going to tap for the answers. As soon as I have those answers, I will post the new video right here. Meanwhile, leave your thoughts in the comments section. And watch this video next where Congressman Thomas Massie tells us how we can work with our local government to ensure the same kinds of things don't happen in our state.
It's very similar at the state level. Oftentimes in state legislatures, it's easier to get a bill through committee and easier to get it to the floor. In the House of Representatives, it's like pulling teeth.